Hi, my name is Justin Kasiba, an attorney with Hensley Legal Group. I'd like to take some time to prepare you for your upcoming Social Security disability hearing. During this video, I'd like to go through what to normally expect with your hearing and what key participants may be present, along with what your role will be. Before we get into all of that, let me briefly remind you how we've gotten to this point. A hearing has been scheduled because the Social Security Administration has denied your claim at their two lower levels of review, the initial application stage and the reconsideration stage. Those previous decisions that resulted in denials were made by Social Security reviewers who never saw you, but instead based their determination solely on the contents of the file and the rigid guidelines they must follow in making the decisions. By appealing those denials, we have made it to the level of review where a Social Security administrative law judge will be making a brand new determination on your claim. The Social Security administrative law judge that will hear your case is to be a neutral party in the matter. That means that it's the judge's assigned role to keep an open mind and not make a decision until he or she has reviewed all of the evidence in your file, which includes the testimony that will be taken at the hearing. Along these lines, the purpose of the hearing, from the judge's perspective, is to learn additional facts from you to have a better understanding of the situation regarding your disability. When it comes down to it, this case is all about you, and so it only makes sense that the judge wants to hear directly from you about limitations that arise from your impairments and other general information. With that said, the purpose of the hearing, from your perspective, is your opportunity to explain to the judge in your own words why you cannot work based on your disabling conditions. From a more technical point of view, the Social Security Administration assigns the hearing to a judge so that a determination can be made regarding whether you are disabled under their definition of disability. Social Security's definition of disability is the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairment which can be expected to result in death or which has lasted or can be expected to last for a continuous period of not less than 12 months. To meet this definition, you must have a severe impairment or impairments that makes you unable to do your past work or any other substantial gainful work that exists in the nation based on your vocational factors, including your age, education, training, and past work experience. Please note that this definition of disability is unique to Social Security. Taking a step back from those more technical terms, the way I like to break it down is that the judge, in making a decision, ultimately has to answer a couple of basic questions. The first is, what is the most this person is capable of doing on a sustained basis? And then, once the judge has figured out what he or she believes to be the most you're capable of regularly doing, then the second question is, given this capability, are there any significant jobs out there in the nation that this person can be expected to do, all things considered? Of course, when answering these questions, the judge needs to make sure that the answers are supported by the evidence. While this is a bit of a simplification regarding everything that happens, it helps to provide a good basic guidepost about the broad topics that will be covered during a hearing. Let's start talking more about how these hearings are actually conducted so that you can get an idea about the setting you'll be in. The average hearing usually takes about 30 to 45 minutes, but this can vary based on the amount of materials that need to be covered. Wherever it is, you want to make sure that you arrive a bit early so that you can properly check in beforehand. This always begins with a security guard verifying your identity, so make sure you bring a valid picture ID with you, and make sure you don't have anything on you that can be perceived as a weapon. Once checked in, there will be a waiting area and your representative from our office will meet you there. Arriving 30 minutes before your hearing is scheduled should be plenty of time. Make sure that you make proper travel arrangements so that you won't run into any issues the day of the hearing. Sometimes clients will ask if they should bring a cane, a walker, wear wrist braces, and those sorts of things. My rule of thumb for this is simple. Do what you would naturally and normally do. For instance, if you normally wouldn't use a cane out in public and don't feel that you actually need it the day of the hearing, then don't bring it along thinking that if a judge sees you with one, it might help convince them that you are disabled, because it won't. But if you ordinarily would use anything like this, then by all means, of course, feel free to use it. Shortly before the judge is ready to begin the hearing, a hearing monitor will come out to find both you and your representative and will usually want to confirm your current contact information. From there, the hearing monitor will usually go back to get things set up for the hearing and then return to bring you and your representative back into the hearing room where the judge will be waiting. The judge will have reviewed your file before the hearing and will be familiar with the medical evidence and any information that it contains. Now, in all likelihood, I'm guessing you're a bit nervous about attending the hearing and being in front of a judge. Just remember, it's the judge's assigned role to serve as a neutral decision maker on your claim after conducting a hearing and getting a better idea about your case. Judges aren't there to be argumentative or contentious to you or your representative. They should only be trying to work through the issues of the matter. You might also be wondering about how to dress while in front of the judge. You are not at all expected to dress up, as many people who sit in front of them may have problems buttoning buttons and other problems dressing, so they are used to and expect people to dress casually. My only word of caution would be to not dress down too much. For instance, no hats, and during the summer, don't show up in tank tops and short shorts or shirts with phrases on them. Basically, anything that would be distracting and draw attention should be avoided. Other than that, it's probably safe to say that dressing like you would if you were running to the store is fine and is the standard, rather than dressing like you're attending a wedding. As far as the hearing room goes, the judge will have a bench where he or she is sitting. Normally, there are a couple of conference tables that are pushed up against the judge's bench, and you will be seated at the end of one of them so that you are facing the judge. Your representative will be seated next to you. The hearing monitor that brought you into the room will remain there, as it's his or her duty to make an audio record of the event. This is a private hearing, and the only people in the room are those actually participating in it. During the hearing, everybody stays seated in their places. However, with that said, if you need to get up and stretch, that's fine, and you don't need to ask permission to do so beforehand. You do what you need to do, and everyone else will work around it. The only other individuals who might be present at your hearing would be any experts that the judge may use to help evaluate the facts of your case. The experts who appear at hearings are hired to provide neutral testimony. In other words, similar to the judge, their role is not to be for or against your claim, but instead it's their job to merely state the facts in the record and their opinion when asked, based on their background, education, and professional experience. It's important to realize that regardless of what experts might say, they are not making any determinations in your case. Rather, they are there to offer their insight regarding things that might be outside the scope of the judge's general knowledge. However, if the judge doesn't find what an expert is saying to be consistent with the evidence, the judge may still give little bearing to what the expert says when ultimately making a decision. One type of expert that is present in virtually every case is a vocational expert. In basic terms, this is a person whose career involves studying what types of jobs exist in the country and also what may typically be required both physically and mentally in order to perform those jobs. Therefore, a vocational expert is used in a hearing to help categorize the type of past work that you had done based on the duties you had performed, and also answers any questions the judge or your representative have about whether a certain hypothetical set of restrictions would eliminate the possibility of an individual returning to past work or sustaining other work. A vocational expert is the only expert that is standard in every hearing. However, in some cases, certain judges will have a medical or psychological expert present as well. It is up to the judge as to whether these experts will be involved in the hearing. If used, these experts will have reviewed your medical records prior to the hearing, and during the hearing, the judge will obtain their opinion regarding your impairments and restrictions based on their review of such records. I've mentioned a vocational expert, a medical expert, and a psychological expert. Those are the only types of experts ever used in a hearing. Most of the time, the vocational expert is actually present in the hearing room, but if a medical or psychological expert is used, oftentimes they commonly attend only by telephone. In every hearing, the judge should begin by running through a few procedural matters in order to make sure that you and your representative are ready to proceed. This is a conversation directed towards the representative. Normally, it will begin by making sure that the representative has reviewed the file and all of its exhibits and to see if there are any sort of legal objections regarding anything that it contains. From there, the judge will usually ask whether the record is complete or whether there might be any outstanding documents that still might be expected to be submitted in the future. Judges do this to make sure that they do not make a decision before they have received all the expected evidence in a case. Judges will also ask your representative if they have explained to you the issues that are to be addressed as outlined in the notice of hearing, and accordingly, whether the judge can then forego a further reading of the procedural history and statement of issues. Next, the judge will swear in all witnesses expected to testify. Once these basic things are done, then we're ready to get to the real substance of the hearing, the testimony. When collecting testimony, judges almost always start with getting your testimony first. With the way hearings are conducted, the judge and your representative will both have the chance to ask you questions, and in a sense, this is done pretty informally. There is no designated order in which questions are asked, and oftentimes, even if your representative is in the middle of asking a line of questions, the judge may step in to ask for clarification while on the topic rather than waiting until your representative has finished taking all testimony. Also, because this is a fact-finding hearing, the types of questions allowed are quite broad and are oftentimes asked in an open-ended manner. I'll run through some common topics of questions in a moment, but beforehand, I want to run through a few principles to keep in mind when responding to questions. The most important rule, which I hope should go without saying, is to be honest with all of your answers. Almost every representative at some point in their career is going to have a client that goes against this advice for one reason or another, maybe thinking that by exaggerating symptoms or denying certain facts, they're helping their case. Trust me. This usually doesn't end well, because once a judge catches wind that something clearly doesn't add up, then a judge isn't likely to find the rest of that person's testimony credible or believable either. Second, you should fully understand the questions asked to you before answering them. If at any time you are confused, make sure that you ask for clarification or for the question to be repeated. It doesn't do anyone any good if the questions or responses are taken out of context, because if nobody is on the same page, then no meaningful information is obtained. Similarly, make sure you are answering the question asked. It's a good thing to elaborate on an answer, but just make sure the response is sticking to the original question and not getting completely off track. If the judge or your representative want information on a different topic, leave it up to them to guide the testimony in that direction by asking the appropriate follow-up question. Otherwise, if you change topics with a convoluted response, then you may be distracting the judge or your representative away from their line of question or thoughts, which may make it harder to get back to them. It can also test the patience of the judge and make it harder on the judge to keep things straight as they're trying to review the claim. Next, if you don't know the answer to a question, just keep in mind that it's fine to let the judge know that you can't remember or don't know something. With a lot of questions, though, a judge or representative is merely trying to get a basic idea about something and isn't expecting something exact. For these, answer as precisely as you can, but at the same time, if you're not confident about something, then just make sure you're letting the judge know that something might be your best guess or that it's to the best of your recollection. A good example of this is if the judge asks you what's the most you can lift. In all likelihood, this isn't something that you've tested with any accuracy, and it can also vary day to day based on how you're feeling. But rather than saying, "I don't know," instead try to think about what might be the most you're comfortable with lifting and respond that way. For instance, you might say something like, "I don't know what it weighs, but a gallon of milk is about as much as I can lift anymore." A response like this is a lot more helpful than just saying "I don't know," and it can at least give the judge an idea about things. But don't respond with something like, "I don't know, maybe 2 pounds because a gallon of milk is about all I can lift anymore." In that response, you're essentially giving two different answers. On the one hand, you're saying you can only lift 2 pounds, but in the same sentence, you're saying you can lift a gallon of milk, and that actually weighs about 8 pounds, or 4 times as much as you just said a second beforehand. While a judge may realize that what you meant was that you can lift whatever a gallon of milk weighs, you can still probably see how this can reflect poorly on your ability to give the judge reasonably reliable estimates. So avoid filling in with this sort of inconsistent information. Along similar lines, it's important not to be too rushed with your responses. Just know that it's okay to take a moment to pause and to gather your thoughts if necessary. Giving slower but accurate testimony is always going to be better than rushing through testimony but being imprecise or inconsistent. The next principle to keep in mind with testimony is that the only record of the hearing is going to be an audio recording, so make sure you verbalize your answers out loud. That's because even though the people in the hearing might know exactly what you mean as the hearing is happening, if the claim was ever reviewed for any reason, then on review it would be impossible to take away any meaningful information from the audio recording where an answer wasn't verbalized. For instance, don't just say that you have pain here if the judge asks. If you were just listening without watching, that wouldn't mean anything. Instead, you can more effectively say, "I have pain in the base of my neck." That provides a much clearer record. That's all I wanted to mention about things to keep in mind when giving testimony. Now that you've heard them, I think you'll agree they're pretty simple concepts. Let's briefly now turn our attention to some of the types of questions and topics that are covered at a basic hearing. First, the judge may want to get more information on the type of work that you've done in the past 15 years. The judge will want to get an idea how strenuous the work was and other sorts of factors that existed on the jobs, such as whether you were responsible for supervising, hiring, firing, dealing with the public, or any sort of special conditions or skills that were part of the job. Regarding how strenuous the work was, the judge will mainly want an idea about how long you would have to sit, stand, and walk, and what would have been the heaviest thing that you'd occasionally lift on the job. The judge will also want to understand why work ended. The judge may already have a lot of this information in your file and may not spend much time on it unless there is a need for clarification. Instead, most of the hearing is spent with questions that are aimed at making sure the judge understands the symptoms and limitations you have due to your medical impairments. The judge is trying to gain information on how the symptoms have a practical effect on your daily life. Usually, the judge will want to walk through what a typical day might consist of for you and point out any problems that symptoms might give you along the way doing your activities. The judge will want to get an idea about how the household tasks get done around the home. Also, the judge will want to know about any sort of hobbies or work attempts that you may have attempted recently, and also about any social activities that you may engage in. As I hinted earlier, the judge will normally want to know about how much you can lift, and also approximately how long you can sit, stand, and walk at a time. If there are limitations regarding these things, the judge will want to understand why. The judge or your representative may want to get clarification about your course of treatment and how it has affected your symptoms. Aside from treatment, a judge or your representative may want to know about anything else you might do to help alleviate your symptoms, and also what kinds of things make your symptoms worse. Along with that, if there are any side effects from medications, those will usually want to be discussed at a hearing. Judges usually ask standard questions, making sure that you have been compliant with medications to the best extent possible, and also inquire about any alcohol use and about whether or not you smoke. Like I had mentioned earlier, the judge is ultimately trying to determine what might be the most you're capable of doing on a sustained basis. So questions are going to revolve around anything that might help gain insight on that. Between the judge and your representative, they should obtain testimony about any restrictions and impairments you're believed to have. You will have the chance to talk to your representative prior to the hearing, if you haven't already. At that time, he or she will go through any more detailed issues that might be relevant to your particular claim. One other thing to keep in mind is that a judge typically will not make a decision by the conclusion of the hearing, but will instead end the hearing by saying that the matter will be taken under advisement and that when a decision is reached, a copy will be mailed to both you and your representative. Generally, these decisions are mailed out about 60 to 90 days following a hearing. That's all I've got, so thank you for taking the time to watch this video. And hopefully, this has given you a good foundation regarding what to expect at the hearing.